Telecommunications Partner at Rajah and Tann Singapore LLP. Mr. Deepak Pillai, Technology, Media, Telecommunications and Data Protection Partner, Christopher and Lee Ong. Mr. Supawat S, Partner, Technology, Media and Telecommunication at Rajah and Tann, Thailand. Mr. Zacky Zainal Husein, Head Technology, Media and Telecommunication at Assegaf, Hamzah and Partners. I would request Mr. Sriram to take over from here and start the session, please.
Thank you, Sriraj. Pleasure and honor to be here. Very grateful to have the opportunity to moderate this session. It's a very important session, primarily from my viewpoint. I'm a partner with Rajah and Tann Singapore, but I also am part of the South Asia desk at Rajah and Tann. And within the South Asia desk, we're clearly seeing greater flow of business between South Asia, in particular India and ASEAN. There are technology companies that are looking to come into ASEAN to set up their practices and their businesses. There are also MNCs that are based in ASEAN, as well as ASEAN companies itself who have their technology back office, especially in India. And as ASEAN progresses on its digital economy pathway with mega trends such as the Digital Master Plan 2025 set to gain speed, we think the digital economy as well as cybersecurity issues will become front and center stage. To discuss the issues relevant to cybersecurity laws and compliance, especially with ASEAN, I'm very grateful for my partners from the RTN network to have joined this panel. I dare say this might be the best panel to speak about cybersecurity laws within the ASEAN. To lead it off, we have Steve Tann, my fellow partner in the Singapore office, who will speak about the Singapore cybersecurity laws. He'll be followed by Deepak from Malaysia, followed by Supawat from Thailand, and finally, to round it all off, it'll be Zacky from Indonesia. Each presentation will focus on their particular jurisdictions, cybersecurity laws, jurisprudence, and some developments. 10 minutes for each is actually a very, very short time even to scratch the surface of this very, very big topic. And so without further ado, may I just start by requesting Steve to kick off the sessions with a prognosis on Singapore and the Singapore's laws in particular. Steve, over to you.
Yes, thank you, Sriram. So what I'm going to do now, good day to everyone. What I'm going to do now, because in this short span of time, there's actually plenty to cover, but I need to restrict it to just about 10 minutes. Let me just put up my slide deck. If I could just push this up. Hang on. It's okay. Hang on. It's not. All right. There's a problem with the. Give me a moment. Yeah. Let me just the interface is giving me a bit of a problem. Let me just give me a moment. Okay. Is it happening? Oh. Okay. Okay, I have a problem with the interface. It is not showing me the blue share. Okay, I see it now. Hopefully I can do it. Okay, yeah. Finally got it.
Perfect, you're good.
Yeah, sorry everyone. For some reason there was an issue with that. Okay, so what I'm going to do is I now have to do this pretty swiftly. Okay. So today, so for myself, I'm just going to give you a very quick macroscopic perspective on Singapore, and obviously I'm looking at recent developments as far as the Singapore regulatory framework is concerned. Before I do that, perhaps share with you some stories, some stories that have taken the headlines. Certainly, the one that's taken the one of the biggest headlines in the last recent years would be a data breach that happened in the health industry. The SingHealth Group, which included IHIS, the Integrated Health Information Systems, was fined a whopping fine collectively of $1 million. And obviously they had to put in place new cybersecurity steps. And if you think that, being in the finance industry, you're insulated to some extent because of how regulated you are by finance-related laws, well, think again, things can go wrong, and it can even go wrong for, for even the stock exchange, right? Look at, last year, New Zealand Stock Exchange, they were halted by a cyber attack. What happened was actually one of perhaps the simplest vectors of attack, which was a DDoS attack. DDoS attack is for, most of you would know what it is. Some of you may not. Well, it's essentially where malware has been planted in IT devices, such as it could be a wireless router, it could be any other IT device, and collectively they come together to make connections with your online platform at the same time, overwhelming your platform such that your platform can no longer operate. So that's a DDoS attack, right? So to make things worse, a bit later, the stock exchange itself was blasted by its regulator in terms of it not having been prepared enough to deal with this sort of attack. So, really in your own jurisdiction, these things can happen when they least expect, and do be prepared for it, especially if you are in a regulated industry as you are. So in terms of Singapore, right, there are a couple of pieces of legislation that deal with cybersecurity to some extent. Obviously, you've got the Cybersecurity Act, which gives our cybersecurity agency power to require designated critical information infrastructure providers to do certain things from a cybersecurity perspective. There's also the Personal Data Protection Act, which is an omnibus act. And certainly for India, you're now looking at a new Personal Data Protection Bill as well. There are other laws such as the Banking Act and regulations, as well as most recently an updated MS Technology Risk Management Guidelines, which requires more involvement by senior management. And of course, Computer Misuse Act. These are just some examples of the pieces of legislation. I'll be focusing on the PDPA in terms of the most recent developments. Why? Because two reasons. One is because of the high level enforcement that's happening in Singapore, right? When we talk about enforcement in the region, I believe Singapore, it's not a rat race, right? But essentially, based on the track record of our regulator, I believe we trump the other jurisdictions in terms of the numbers. Statistically, you can see it for yourself. Quantum leap between 2017, 2018, and 2019. And this is just the tip of the iceberg. At any point in time, there would be perhaps 2 to 3 times more investigations happening. It's only a couple of investigated cases that eventually turn up to become a reported decision. Why? Because there are learnings to be made from these decisions. So the second reason why I want to focus on the PDPA, Personal Data Protection Law, is because quite recently, on 1st of February 2021, a new data breach notification obligation came into force. So this is a mandatory data breach notification regime, which you can see in the GDPR, for example, in Europe, which you can see in Philippines as well. Thailand, you can see it in their act. Supawat may be talking about it in a while. I believe Malaysia will be considering it as well. They don't have it as yet, but I'll leave that to Deepak to talk about as well. Now, so in terms of this mandatory data breach notification regime, why is it so important? Is because when you weigh the fact that enforcement is already so high in Singapore, and now you have a mandatory data breach notification requirement, it makes it actually even more stringent from an organizational perspective, because no longer can you sweep data breaches under the carpet, right? And the question then we have to ask ourselves is, what sort of data breaches require us to notify the regulator of that breach? So first off, we need to so there are 2 requirements, right? The first is what is considered a data breach, right? That could trigger this obligation. And for here, we look at, there are 2 parallel definitions, or rather there are 2 limbs to the definition of a data breach under Singapore law. You have, the first one is where there's been unauthorized access, collection, use, disclosure, copying, modification, or disposal of personal data. So this differs to some extent. Singapore always likes to be unique to a certain extent. This differs to some extent from what you can see perhaps in Philippines data protection law, from what you can see in the GDPR, because the GDPR does define it as a security incident that results in an unauthorized access, whereas ours has cast the net wider. It simply is unauthorized access, collection, use, and so on. We've got a second LIN, right, which focuses on storage medium and device, which you don't really see in other jurisdictions. And this is, as stated here, loss of any storage medium or device, so on and so forth. You can read it for yourself because I just want to move on. Now, once you've established that there's been a data breach, right, you then need to ask the second question. Has the notification threshold been met, right? And this is a notification threshold, right, of what is notifiable. So you have a data breach. The first notification threshold, we have two notification thresholds. The first is if the breach has resulted in or is likely to result in significant harm to the individual, right? So this is quite similar to what you can see in GDPR, in many other jurisdictions as well that follow the GDPR. And in such a case, you've got to notify the regulator, the PDPC, Personal Data Protection Commission, and the data subject as well. Considering the fact that our regulator is so strict in terms of enforcement, you obviously want to avoid notifying them if you can help it, but no choice. If you meet this LIN, you've got to notify them. Now, the second LIN is where we differ from other data protection jurisdictions, right? And this is where there's no risk of harm to the individual. So the data breach has resulted in no risk of harm at all. Now, when you look at the GDPR, you look at other jurisdictions, it's all about notification can only arise if there's a risk of impact or harm to the individual. But for Singapore, we've taken a step further. We're saying that, well, I would want notification to occur even if there's no risk of harm, provided that there's been a significant scale. Significant scale simply means that the number of affected data subjects has crossed a certain threshold. And in this case, the number would be 500 or more. So simple example would be pre-COVID, right? You organize an event and you have got the name list of people who are attending that event. So just names as well as the fact that these people are attending your event at that date and time. It's still personal data. That document still contains personal data. What if on this name list there are 600 names? If you, for example, if you fail to securely destroy this name list and it's lost somewhere or it's taken by someone, then arguably, well, there's no risk of harm because everybody's name is out there, right? But because the scale has crossed the 500 threshold, unfortunately, you've triggered the notification threshold, and you've got to notify our regulator at this point in time. So I think I've already reached the 10-minute mark, and I think I will stop here. All right, and I'll hand it over to the next speaker. Now, if I could just stop sharing.
Many thanks, Steve. May I invite Deepak to take the stage?
Yes, hello everyone.
Thanks, Deepak.
Good afternoon, as it may be in India and in Singapore as well. I'm going to be presenting on Malaysia. Let me just get my slides in order. One moment, please. Okay, so cybersecurity in Malaysia. In terms of cybersecurity laws, there's no single overarching cybersecurity act as they have in Singapore. It was proposed in 2017, but due to the government of the day losing the elections, it was never tabled. Other than the laws of general application, by which I mean Penal Code, Copyright Act, Sedition Act, so on and so forth. In fact, there's a listing at the Prime Minister's Department, which lists 31 different acts where they have been amended to include prosecution of offences in the digital medium. The main laws from a cybersecurity perspective are the Computer Crimes Act, which criminalizes unlawful access, modification, and communication of information or passwords. Secondly, there'll be the Communications and Multimedia Act, which regulates the telecommunications infrastructure and services, as well as content. So it criminalizes misuse of the network, it criminalizes objectionable content and sets standards for use. And thirdly, we have the Personal Data Protection Act, which subjects data controllers to certain security standards, because that's what we're talking about, which if breached could result in the data controller being fined, imprisoned, etc. So these laws are actually supported by a whole host of standards. We have the security standard under the PDPA, supported by strategies. We have overarching Malaysian cybersecurity strategy document, which is supposed to be effective from 2020 to 2024, and a variety of guidelines for specific sectors, as we will shortly have a look at. But in terms of data protection, Steve spoke about data protection primarily in Singapore. Admittedly, it is definitely more advanced, even though we started about the same time, and Malaysia is still in the building awareness stage. They have not moved on to the enforcement. At the moment, it is basically addressing the low-hanging fruits. So basically, you're required to register, have you registered or not? So it's very binary, and there's been no investigations or cases involving complicated issues. So moving on, what you see on the screen are some statistics for Malaysia in respect of reported cyber incidents. I don't like saying this, but unfortunately, I may need to. Cybercrime is alive and well in Malaysia. In fact, it seems to be a thriving business. Looking at the facts, these are statistics from the Royal Malaysian Police. It shows that the number of cybercrimes reported to the police in 2018, 2019, and 2020 are on the rise, with the cases in 2018 being 10,000, about 10,000, 11,000 in 2019, and in 2020 it is 14,000. In terms of losses, they are on the way downward, around 400 million Malaysian ringgit in 2020. While the amount of losses associated with cybercrime seems to be declining, the statistics actually show that the number of cases continues to increase. And I can assure you that what you're seeing on the screen is only part of the picture. For every case lodged with the enforcement authorities, there's likely to be 1 or 2 or 3 cases where the victims do not report the incidents. So in my practice, so these are statistics, and then we have my practice. I've seen tremendous increase in cybersecurity related matters affecting Malaysian corporations, whether in terms of phishing attacks ranging from those affecting public utility companies, transportation companies, investment banks, to data breaches, which might affect banks, insurance companies, e-commerce enterprises. So it is happening. But if you look at the statistics, it doesn't address the corporate related data breaches or phishing attacks. So these statistics seem to be more targeted at, or rather reflective of what's happening to consumers. And then moving on quickly to the cases that have been brought over the past 3 years. So as you can see, there's cyber criminal cases on the left, and on the right, you've got civil cases. In each year, 100 over cases are registered, and about 100 cases are actually disposed of. So if you look at the total figures, it's basically 300 cases a year. So this is a ratio, if you compare with the list of incidents, 10,000 to 300. So it's 33 cyber incidents for every 1 case that's brought into court. This is a ratio that can be improved upon. And I think that we are definitely doing our best to improve upon it, but it's taking some time. So these are some of the cases that have been brought today. I won't go through each case. I'll just mention what it's about. So the first one on the top left is unauthorized access under the Computer Crimes Act, unauthorized modification, obscene communications, dishonest concealment, cheating and inducing delivery of property, false communication, criminal intimidation by anonymous communications, insulting a person's modesty, and then you also have cyber fraud, liability of online marketplace operators, unauthorized disclosure of private information, cyber harassment, and cyber stalking. So it is alive and well, but is it at the extent, at the level that it should be? I don't think so at the particular moment. So now taking more of a macro viewpoint, the one thing that I'd like to draw your attention to is the Malaysian Cybersecurity Strategy of 2020 to 2024. This was launched in 2020. The MCMC, which is our Communications and Multimedia Ministry and Commission, as well as the National Cybersecurity Agency, were tasked with formulating, implementing action plans under the Malaysian Cybersecurity Strategy. But then again, when you look at the cybersecurity strategy and you look at the pillars, they've set out 12 strategies, 35 action plans, and 113 programs. That's a lot for anyone to manage. The question is, why don't we have a Cybersecurity Act like Singapore does? And I think that's a step that needs to be taken. But having said that, under the Malaysian Cybersecurity Strategy, they have indicated that in 2024, at the end of the process of putting these regulations into place, they are proposing to launch a Cybersecurity Act. So now moving on to talk about the sectoral approaches. So this is where I think a lot of the work is being done. You have got the capital market sector, where they have got a guideline on management of cyber risk, which sets out cyber risk management requirements for capital market entities. And then you've got the financial services sector, where they have a risk management and technology guidelines. So these guidelines actually go back longer than 2020. They were there in a different form prior to that. But these set out our central bank's requirements on technology risk management for financial institutions. And then you've got the communication sector, where they've addressed network security and set out technical codes on incident management and cyber insurance acquisition. And moving on, so this is the last slide. Essentially, what can we expect to see over the next few years? As I mentioned at the beginning, since 2017, the Malaysian government had indicated its intention to enact the Cybersecurity Act. Is how it's been parked for the time being, and looks like it's going to only come into force in 2024 or 2025. And over and above that, as I indicated, the Malaysian cybersecurity strategy does talk about future plans and the fact that they're going to enact a cybersecurity law in 2024. The one thing that is clear is that for personal data protection, there is going to be a data breach mandatory notification system put into place. Unfortunately, right now, Parliament is suspended because of the pandemic. But as soon as Parliament comes back into session, I believe that the Amendment Act will go through. And once that is through, there will be a requirement for mandatory notification to the Commissioner in the event personal data is breached. So that will give you an overview of the situation in relation to cybersecurity in Malaysia, what our challenges, what are the things that we hope for going forward. And at this point, I will thank you, right? And yeah, I'll let the next speaker.
Thanks, Deepak. Supawat, stage is yours. Thanks so much.
Okay. Thank you, Deepak. Thank you, Sriram. Actually, let me, open my slide. Okay, when we talk about Thailand overview, I mean, on cybersecurity laws and compliance regulations. Actually, if we talk about numbers of regulations, Thailand is second to none. We have so many. Okay, let me. Okay. Yeah, in terms of number of regulation, we are second to none. So we have so many regulation in place when we talk about cybersecurity laws and compliance in Thailand. But the issue that we have right now is not about the provisions of law itself. The issue that we have right now is the implementation and enforcement. For example, I mean, today I will focus on three main laws. First, Computer Crime Act. Second, Cybersecurity Act. And third, Personal Data Protection Act. Actually, out of the three, only Criminal Crime Act is fully enforced. Cybersecurity Act and Personal Data Protection Act, somehow we still have some issues on the implementation. It's not a full implementation yet. We are waiting for subordinating laws to be in place and also the regulators to set up and supervise or regulate. Okay, let's talk about the Cybersecurity Act first. Actually, Computer Crime Acts, I think similar to other jurisdictions, we are Thailand focusing on hacking, unauthorized access. We're focusing on denials of service, and we are focusing on phishing. Actually, there are a couple of series of wrongdoings that mentioned in the regulation in the act, but this the three main areas that the regulator right now focus heavily. We can see. I mean, the reason that I can see that I say that we focusing on this quite heavily because I can see from the numbers of enforcement by the authorities. We don't have the formal statistic like Deepak show in for Malaysia, but we can tell that there are a lot of cases going on right now. You know, hacking, for example, we can see that there are a lot of not data leak, but someone try to attack the system of certain companies, for example, telco or other service providers, such as banking, for example. So that's why we are in terms of law enforcement, we are focusing on this quite heavily. Next one, Cybersecurity Act. Like I said before, we have the law in place in 2019. We have the law on Cybersecurity Act, but the issue that we have right now is that we are waiting for implementing regulation to be put in place, and because the main law doesn't mention the detail. For example, we are focusing on the standard. I mean, how you have to come up with certain measures or system just to prevent from the cyber attack. But the standard that you're gonna use or the company have to apply is not mentioned in the law. So we are waiting for the regulation. I mean, implementing regulations to specify what kind of system or what kind of standard that the government require from the business operator. For example, right now we have the public hearing on the regulations. So we are asking, or we just debating in the public that which standard that we going to use. For example, ISO or IEC. So we expect for the Cybersecurity Act, we expect, I mean, like implementing regulation, we expect that everything to be ready by next year. But anyway, because of the COVID right now, it's a bit. My assessment is that maybe it will postpone to maybe another one more year. So that's the Cybersecurity Act aspect. So the next one would be data protection, Personal Data Protection Act, so-called PDPA. Actually, when we talk about Personal Data Protection Act in Thailand, there are two news, good news and bad news. Good news for business operators. I mean, especially if you already do business in other jurisdictions, especially in Europe, for example, you probably get used to with GDPR, like Steve mentioned before. The good news about this, if you look from type aspect, I think we would say that if you comply with GDPR, you should be okay under PDPA, because I would say 85 or 90% of our PDPA quite similar to GDPR. But the bad news is the 15% or 10% that I mentioned slightly different, and that one, for example, contain criminal penalties. Unlike GDPR, you are dealing with monetary fine. For example, you don't have to worry about your freedoms as a businessman doing business in other jurisdictions. But in Thailand, you probably have to think a lot because it involves criminal penalties. So that's the bad news about doing business in Thailand when we talk about personal data protection aspect. We have a lot of cases going on already, even we don't have a full implementation. For example, we have problem with hackers. They hack so many personal data from telco service provider. So I think right now, even we don't have the full implementation yet, I think the authorities also work with the company quite closely on that aspect. The second case, for example, we have Post company. Actually, it's a state-owned enterprise, and somehow we have some issue about data leaks. So the issue that the data that leak is names and phone numbers of user, customers of the Post company. The third one is about airline business. We also have, similar to other jurisdiction, we also get attacked by hackers also somehow, for some reason, they said it's not hacker, it's just leak because it's open to public already. We don't know why we have this kind of incident, but again, the authorities also pay a lot of attention to this regulation. So last but not least, I just want to mention about the enforcement of the law. Like I said, apart from criminal Computer Crime Act, Cybersecurity Act, and Personal Data Protection Act is not fully enforced yet. Personal Data Protection Act, the next target that the government want to, already mentioned in the law that they postpone to next year. So I think similar to Cybersecurity Act as well. So next year you will see a lot of development from Thailand on data protection and also Cybersecurity Act. Thank you. Back to you, Sriram.
Thanks, Supawat. Zacky? Hi, Zacky. Yes, floor is yours. Hi, Zacky. We can see your slides. We can't hear you.
There you go. Sorry about that.
Yeah, you're good, Zacky.
Okay. Good afternoon, everyone. For Indonesia, I have to apologize to the organizer and the panelists because I will be stretching a bit my presentation and not just focusing on cybersecurity. I was hoping to be able to share something on the Indonesian Data Protection Act, but it remains it's still being deliberated at the parliament. It's not getting any closer to completion, and there is really nothing noteworthy with respect to the Cyber Security Act. So what I'm hang on a second. I'm not sorry. Do you see my presentation?
Not yet, Zacky.
Oh, I thought it was on.
No, Zacky, we're seeing your computer. We're seeing your files.
Oh, sorry.
You might want to stop share and then share again and choose the PowerPoint.
Okay. Close everything. I'm sorry. I lost the the screen here.
You'll have to stop the screen share and then try again and click on the application which you want to share.
Zacky, if it helps, would you just
Yeah.
leave the presentation and just give an overview of the Indonesian regulations?
Sorry. Okay. There you go.
Okay. Yeah. Okay.
Okay. So as I was saying, there is nothing. Our Personal Data Protection Act is not complete yet. It's still being deliberated in Parliament, and there's nothing noteworthy with respect to the cybersecurity to be shared. But there is a lot of development towards the end of last year with regard to the other sectors, which is if you stretch the cybersecurity into ICT, and then there is this huge component of telecommunication, and that's the area that I'm going to be focusing on. So at the end of 2020, at the backdrop of the pandemic, the government were thinking about how to create employment, basically. So they passed what we call a job creation law. It's basically is an ambitious program of amending simultaneously 76 laws. That's why it's called a omnibus law, with the key objective of improving investment and licensing ecosystem. So the thinking is to open up new areas which was previously restricted in getting a foreign investment, and also to streamline the licensing process. And the licensing process is mainly achieved by putting it into one, what we call a online system, the single submission, online single submission system, the OSS system, which cuts down a lot of the red tape that previously existed in terms of licensing. So, for example, one of the sector that was included in the amendment in the omnibus law is the telecommunications sector. In terms of the substance, for example, I'm using an example here of the on infrastructure. So previously, for infrastructure, it was really dedicated. It was really something that if you are a service, if you are a network provider, or if you are a service provider, it's something that you have to develop on your own. There is a possibility of renting it or leasing it from another provider, but that is usually very limited. Now, under the amendment of the law,
Apologies for the technical glitch. While we wait for Zacky to come back, maybe I can use the time to ask one quick question. Steve, if I could ask you a quick question that's come on the chat screen. And this would relate to PDPA probably, because the question is, what are the major amendments brought out by the regulator, maximum penalty levied for violation? It's jurisdiction agnostic, the question, and doesn't speak about which legislation. But perhaps if you could just look at PDPA, given that the personal data protection is a theme that runs across almost all the ASEAN states, except differing stages of evolution. Any major amendment that's been brought out by the regulator, and what's the maximum penalty for data breach under the PDPA?
As a network provider, you are restricted to 67%.
I think Zacky is back on. Yeah.
So this is something
okay,
that which
maybe
is
Zacky can finish. Okay.
Okay.
Which is new. Okay.
Zacky, we lost you. We lost you for 1 or 2 minutes. Okay, he's gone again. Oh no. Okay. Lots of buffering, lots of so telco connectivity in Indonesia. I don't know. There may be some disturbance in the submarine cables today. But you can hear me, right, Sriram? Sriram, shall I go on to answer your question?
Yeah, please,
okay.
Steve. I think
Okay,
so.
so maybe just a quick broad brush of from ASEAN perspective, when we talk about penalties, some jurisdictions such as what Supawat, I believe you mentioned it. The significant thing about it is criminal offences. In a recent round of amendments as well for Singapore, we have started to criminalize certain activities by employees, whereas previously for the last 6 or 7 years, actions or omissions by, or rather deliberate actions by employees where they use personal data without the authorization of the company would not amount to be a criminal offense by them, but could land the company in hot soup itself for being in breach of data protection law. Right now, what has happened with the amendments is if there's been unauthorized and reckless or intentional usage of such personal data or disclosure of such personal data by the employee could, would be guilty of a criminal offense. The other thing as well, if we just talk about civil fines, right? I think across the ASEAN region, probably Singapore is the one with the highest fines. But you never know. The other jurisdictions could very well, get a leg up over us and make amendments and increase the fines. So as of 1st of Feb 2021, the fines that we're looking at would be the higher of either 1 million Sing or up to 10% of the annual turnover of that company. So obviously, if that annual turnover of that company is $100 million, then you know that it's going to be, the fine is up to $10 million, right? In that sense. It's when you marry both the increased fines as well as the fact that enforcement is so high in Singapore. If you're looking at compliance across this region, the APAC region, the ASEAN region, then really, what you need to do, because if you've only got so much time and you've only got so much budget, you've got to then focus and look at which are the jurisdictions for which enforcement is high and for which penalties are high, and then work on it from in that descending order, with the highest being right at the top.
Thanks, Steve. Deepak, Supawat, anything to add on that point?
Yeah, from the Malaysian, sorry, Supawat. From the Malaysian perspective, the fines are much less. The maximum fine is $125,000 US. It's never been, nothing close to it has ever been imposed over the past 10 years. So, but as Steve said, the thing about being in ASEAN is there's probably a criminal penalty there as well. And our jail terms are up to 3 years for breaching the PDPA, the Personal Data Protection Act. Yeah.
Quick one, I forgot to mention, the 10% of annual turnover is in suspension at this point in time, just in case you're worried. It's already been passed into law, but it's been suspended. So it may be, the suspension may drop and it come live perhaps next year. But let's wait and see. What over you?
Yeah, actually, I agree with Steve. I think we heard about, as a lawyer, we have heard about tax planning. I think these days we also have to think about, personal data planning. I mean, how we do things with personal data in each jurisdiction. For example, like you said, we have the company probably need to think from the file perspective, or even criminal penalties. I mean, jail term perspective. I don't want to say that we should avoid complying with the law, but somehow you probably need to think whether you want to put your people at risk or not. And meaning, for example, directors, you may have like some directors stay overseas and doing some business instead of having someone in some jurisdictions. That's my idea. Again, I don't encourage people to avoid any law enforcement, but it's become like, tax planning. So we have to plan ahead.
Thanks, Kunchapwat. I take that lead that Kunchapwat has said in terms of, very nicely said, in terms of just like tax planning, you need to do tech planning. And especially in the ASEAN, I think given the jurisdictions and given the pace at which digital economy is progressing, businesses that are moving to ASEAN or are interested in ASEAN should look at tech planning very carefully. The data protection aspect is something that needs significant attention. And you would have seen from the panelists how the evolution of data protection is evolving around the ASEAN. So with that, it leaves me to thank my fellow panelists, Steve Tann, Deepak Pillai, Supawat, and Zacky. Apologies for the little technical glitches on the platform, but we hope that the audience got an overview of the evolution of cybersecurity laws, especially data protection within the ASEAN countries. And if you need further assistance, the experts are there on the screen. Please feel to reach out to them. Thank you again to the audience and to IMI for this opportunity. Thank you.
Thank you so much, everyone, for such an engaging discussion. And a special thanks to all our panelists and the moderator for being here with us today and making this possible. And another thanks goes out to all the attendees who are here with us today. Thank you so much, everyone. And we'll be back soon with the next session. Please stay tuned.
Thank you, everyone.
Thank you.